Well, good morning. Bob Kerrigan with you for the Law Show this morning, this Sunday morning. Glad to have you with us. We have a lot on the agenda today to cover, including text messages we've received from some of you all about questions that you have and issues that we are going to discuss today. Now, last week, I talked about the racial and ethnic disparities in fetal deaths and had some interesting responses to this. We talked about the overwhelming disparity between African American women and Hispanic women and white women in terms of fetal mortality. So one of the articles that was sent to me came from a publication called MedPage Today. Thank you for the person that sent it. I don't know who this person was. We just have their text number, and so they didn't give us any initials or their name. And we will not put somebody's name on the air or their phone number or any private information when you communicate with us. But if you want us to designate your name or your identity or whatever, we'll look at that and consider that if it's appropriate. So this was a fascinating story and a troubling story to me, and it was this. A black doctor died after giving birth, underscoring maternal mortality crisis. Now, this is a young woman that was in Indiana University, and the article starts with members of the medical community at Indiana University School of Medicine are mourning the loss of Shanice Wallace, MD, a fourth-year pediatric chief resident there after she died from pregnancy complications last week. And this article has some fascinating facts in it. The death of Shanice Wallace, a black woman, highlights a tragic trend in pregnancy and childbirth outcomes in the United States. About 700 women die from pregnancy-related causes each year. Astounding, is it, in the United States? 700 women. And the maternal mortality rate is higher in the U.S. than in any other industrialized country in the world. Shocking, really, isn't it? People of color die from pregnancy at an alarming rate, with Black, Native American, and Alaska Native women 2 to 3 times as likely to die during pregnancy than white women. But let's go back to the underscoring problem here, and that is 700 women dying in the United States at a rate that's higher than any other industrialized country in the world. So this is a very, very big problem in the United States, and it's the sub-part of that problem is the disparity between African American women, Native American women, Asian women, compared to white women in the United States. Black birther mortality is yet another public health crisis that the U.S. has allowed to persist for too long, said Farah Amwe Fullerton, a fourth-year medical student at the University of Alabama at Birmingham, said on Twitter in response to Dr. Wallace's death. Racial disparities, this article goes on to say, in maternal mortality outcomes may occur in part because of the chronic stress that people of color endure from constant discrimination, which can take a toll on their health, a concept called weathering. I'd never heard of this before, never heard of this concept before. This article was sent to me and apparently is fairly well known in the minority communities. You can be a healthy black woman and still have a higher risk of maternal mortality, this physician said. What Dr. Wallace unfortunately highlights is that it's not based on access to care alone. Very troubling article that was sent to me, and thank you to whoever did send it, and send along anything else of interest on the subject. We're glad to look at it and possibly cover it. I'm going to finish my discussion of the grand jury in a few minutes that we started last week. We talked about what a statewide grand jury did, and I want to talk about the NSAIDS and the problems for pregnant women. We'll cover that. Maybe not get to it till this next part of the show in the second 15-minute segment. The Law Show is brought to you by Kerrigan, Rank, and McLeod and Thompson. We're a regional law firm specializing in serious injury and death cases. The Law Show is a public service that we provide to talk about the legal issues. And of course, it's an advertisement for our firm, obviously, because we are telling you about our qualifications to handle the kinds of cases that we do handle, which are serious injury and death claims from a variety of sources. Whatever that source might be, we've handled them all. Train accidents, airplane accidents, products liability cases, dangerous products, defective products, defective crane and industrial equipment products. We've handled medical malpractice cases and the typical kind of automobile accident cases that you see lawyers advertising for. And then they're advertising for those cases because they're easier than some of these other cases, and that is products liability cases, medical malpractice cases, an airplane crash or a train crash or a trucking accident or whatever. Those are all much more complicated. So lawyers are all scrambling to try to represent people in accident cases, again, because it's fairly easy work. An automobile accident case is not usually that complicated. Sometimes you have to get an accident reconstruction expert involved, try to figure out precisely how it happened. Now, we had a case not too long ago where it appeared initially that a mother with 3 children traveling from South Florida to see her mother in Mississippi rear-ended a commercial truck, like a dump truck, on the interstate. And tragic accident, just terrible injuries to her and her family. And when we first got in the case, you say, well, that's a rear end collision. I mean, it was her fault. Obviously, she ran into the rear end of the car, rear end of the truck. But what we learned from a device in the modern cars, there's electronic devices that record everything. And so after an accident, we can go retrieve that data and figure out precisely what happened. And what happened in that case was this dump truck on the road had no adequate lighting, and it was either stopped or going at 1 mile an hour. She was traveling under the speed limit and encountered this truck with absolutely no warning at night and struck it. And so we were able to make a very substantial recovery for her, and the insurance company agreed with us that the at-fault party was the trucking company that owned the truck. And so we made that recovery. So my point is, with these electronic devices in the cars, data recording devices, we can sometimes figure things out that at first blush don't look like the person that was injured in the accident, doesn't look like that they were at fault. It looks like they were at fault, and we get these electronic data things printed out, and it shows us that they were not at fault, or the other party was partly at fault. So my point is that is all available to you now. In the old days, it was very, very hard to reconstruct these kinds of accidents, just almost impossible to go back and figure things out, just like that trucking accident I talked to you about. It was more difficult to do. But now, with electronic data that's in these vehicles, you can recover things pretty fast. So and shed light on how the accident happened. So we got several text messages this last week and emails, but I'll just cover some of the text messages. We try to respond to everybody, even though it might not be in an area that we handle. We make referrals to other lawyers or law firms that we know are specialists in different fields. Ours is limited to these accident claims, but we refer people who text us to other lawyers. But here's just a few of them. This lady said, I bought a brand new construction home. Most couples in the neighborhood have had their issues resolved from the inspections with the builder. She felt that I'm not getting repairs resolved by the builder and have asked over and over for things to be done. It's been over a year. What can be done? Well, I called her and talked to her and made a suggestion about notifying the builder in writing with a registered letter setting forth precisely what needs to be fixed. And that doesn't guarantee the builder's going to do it, but when the builder has it, it helps the builder, can schedule the work that needs to be done, But if you have somebody who's just obstructive and just not going to do it no matter what, well, then you've given them adequate opportunity to address the problem, and then you consult a lawyer, unfortunately, and you have to get a lawyer involved. But I'm hoping that that helped to resolve that. This was a fascinating inquiry to me. He said, you take cases for HIV meds that have been recalled for bone damage. I'm now in a wheelchair due to an HIV medication that I took, not knowing it was causing my hips to lose blood and cause severe damage. I need total hip replacement. Well, several issues about this. The immediate reaction, of course, to the average person is, well, if you have HIV, that's too bad. And there's not much sympathy for the person, which is most unfortunate. But what I did find, the person that wrote to me had the wrong medication. The medication that has been subject to lawsuits in California is called tenofovir, tenofovir, I guess is how you pronounce it. And it has caused serious kidney damage and bone loss, typical of, very similar to what this person wrote to me about. But the medication they said they were taking was this tenofovir was never sold under the name of the medication that this person had written us about. But I responded to them and told them about these claims that if in fact that's what they were taking, the argument or the case is that the manufacturer of the drugs knew that they had a much, much better drug available, but they were making so much money from the sale of this drug that they didn't put out the other drug that would cause much less, if any, damage at all. So there may be something to that, but I thought that was one of the more interesting inquiries. This lady said her mother was transferred from a nursing home to an assisted living facility 9 days before the end of the month, but they'd paid for the end of the month. So anyway, the long and short of it is the nursing home wouldn't give them the 9 days they prepaid back because there was some transfers in and out. So I told her what to do. Again, you write a registered letter. You set forth in the letter precisely what your claim is. And then I told her about filing a small claims action, going to the clerk of the court in the county where she lived, and they would assist in her making a small claims filing against this facility to recover the 9 days that they had prepaid. This is the Law Show. Bob Kerrigan with you. In our second half, we're going to go back to the federal grand jury, talk about the differences between the federal and state grand jury, and cover some other interesting subjects, include the NSAIDS. Medical malpractice is the failure of the physician or the healthcare provider to do what a similarly situated healthcare provider or physician would reasonably do. That's medical malpractice. And so the availability of claims of medical malpractice are unlimited. It's a function of what should a reasonable doctor or a reasonable hospital have done. And if they didn't do it, and they caused injury, then a medical malpractice claim can be brought. I'm Bob Kerrigan. Have you seen the young lawyer advertising standing on top of a truck? I wonder who he would hire if he fell off the truck. Maybe the lawyer who has hundreds of billboards up and down the interstate. If it happened in Florida, though, it couldn't be him because he doesn't even have a Florida law license. He wouldn't hire the lawyer who barely has time to eat with his family because he just seems too busy. Maybe the lawyer who busts down his office wall, but that may not be a good place to be if another wall is crashed through. If he called us, we'd tell him it wasn't the brightest idea to climb up on top of the truck in the first place. With the highest ethical and legal ability rating from Martindale-Hubbell. We represent one client at a time, and we've represented thousands of clients over the years. Your case will be handled by a board-certified partner, board-certified in civil trial by the Florida Bar. Kerrigan, Estes, Rankin, McLeod, and Thompson at Kerrigan.com. Welcome back to the Law Show. Bob Kerrigan with you and talking about various subjects, but I probably failed to say in the first segment that we will respond to your text messages if you will send them to us while the program is airing. It's 850-444-4444. That's text messaging to us. And you can also send us an email, though we don't get as many emails these days as we used to. We get text messages regularly. It's lawshow@kerrigan.com, KERRIGAN.com. Kerrigan, Estes, Rankin, McLeod, Thompson is a regional law firm specializing in injury and death claims. We've been here for many, many years. Started the firm with personal injury litigation in 1973 and have the same partners that we've always had in the firm, Kerrigan, Estes, Rankin, McLeod, and Thompson. So we've been around a long time in North Florida. We have offices across the Panhandle. We're able to consult with people on these serious injury and death claims. We can also affiliate with lawyers outside of the state of Florida. We handle cases throughout Florida without any special admission privileges from the courts, and we can obtain that permission in another state for a special right for us to practice in that state in conjunction with another lawyer or law firm located in that state. And that's to the advantage of everybody involved, because you want local lawyers that know what's going on in their court system. And those are the rules of most states, that you have to be licensed in that state or admitted for special privileges in that state for the case that you're handling. And so that's the way we generally do that. And we can consult on cases outside the United States. That's rather unusual, but we have had them, and we have access to people in other countries that can help depending on where this event occurred. And that does come into play because of our military families, okay? Because we're a big military community in North Florida, as everybody knows. In the first segment, we talked about this disparity in health care for African American women and Hispanic women compared to white women in terms of pregnancies and fetal deaths. It's just a very serious problem in the United States. And the United States, as I mentioned in the first 15 minutes, we have the worst record of any industrialized country on deaths from during pregnancy. It's just alarming to me, because we have just such marvelous health care in so many ways, and really outstanding physicians. I mean, you can criticize various aspects of the healthcare community and healthcare services, but we do have wonderful doctors. And I always said, I want the smartest people in my class to be a doctor, not a lawyer. It's a lot better, because when you go in there, you want the smartest person you can get to be taking care of you. So my brother had a PhD in anatomy and was a professor in a medical school and worked with us for years in our medical malpractice cases. So we've been involved with this kind of work for a long time, and we try to find the best people we can to help us with our cases. And with our medical malpractice cases, we consult other physicians to tell us what's going on here. Physicians that do that exact kind of procedure that's involved in the medical malpractice claim. I will say this about medical malpractice, though, because there's a great misunderstanding about it. The vast, vast majority of people who call us about medical malpractice, we cannot accept their case. And the reason is that you must have in Florida a very, very serious long-term injury or a death before lawyers who specialize in this kind of work will undertake the case. And the reason is it's very expensive to do it. The cases are very difficult, and many people have complaints about what happened to them, but they had a bad outcome. It wasn't malpractice, it was just a bad outcome. And you can have a bad outcome in medical care. So it's unfair to the physicians and the hospitals to assume that because you had a bad outcome that somebody made a mistake. But But you can have a mistake that causes a bad outcome. And that's what a medical malpractice case is all about. Well, some interesting information, by the way, for people who say we don't need the government and we got too much government looking out for us. I suppose there's some arguments for that. But in terms of consumer product safety, we need a vigorous review, because if you don't have a government commission of some kind reviewing products, you can have very unscrupulous people build a product, put it in the marketplace, make a lot of money, and could care less if it's causing death or injury, and especially protective of children. So the Consumer Product Safety Commission is really, really important, and as is the FDA in terms of protecting our health and our safety. And there's nobody else that can do it. If you think about it, who's going to undertake that responsibility to protect the public from dangerous products or dangerous drugs or drugs that have not been properly vetted? If we didn't have that, can you imagine? I mean, it wouldn't be a whole lot different than the stuff that goes on in China and in Russia, where products get out there, they're sold, and no really regulatory control over them. We have that in this country and in Europe as well, but we have that in this country. So I'm very proud of that part of it, and I think it's a critical function of government to provide information to us, not take care of us, not to be our parent in place of our parent, or to be, guiding us in everything we do in our life, but to protect us from things we can't protect ourselves from, which are dangerous drugs and dangerous products, because we don't know about them until somebody gets badly hurt. An arm gets cut off, people take medication and have an adverse reaction that they destroy their kidney or whatever it might be. So the point is, Consumer Product Safety Commission, the FDA, these are parts of government that are there to protect us. And so I highly recommend going to their websites. For dangerous drugs that shouldn't be on the market, the FDA has a long list of drugs that have been taken off the market for one reason or another. And the Consumer Product Safety Commission has a very long list of products that have been recalled because they are dangerous to children. Everything from the way a baby bed's manufactured to a particular problem with an automobile or any other product. And so highly recommend that you go to those websites, the Consumer Product Safety Commission and the FDA. So let me just talk a little bit about some recommendations here that have just come out, and then I'll talk a little bit more at length about it. The FDA is recommending avoiding the use of NSAIDS in pregnancy at 20 weeks or later, because they can result in low amniotic fluid. The FDA recommends avoiding the use of the NSAIDs in pregnancy at 20 weeks or later. The FDA warns about serious problems with high doses of the allergy medicine Benadryl, and the FDA cautions against use of, well, we all know this, hydroxychloroquine. We've all been through that story, but the FDA has said don't use it, for COVID. But let's go to this NSAIDs business and talk a little bit about that for pregnant women, because this is really important, because these are pervasive. These NSAIDs are pervasive in medicine. Again, the U.S. Food and Drug Administration is warning that use of nonsteroidal and anti-inflammatory drugs, NSAIDs, around 20 weeks or later in pregnancy may cause rare but serious kidney problems in an unborn baby. This can lead to low levels of amniotic fluid surrounding the baby and possible complication. NSAIDs are commonly used to relieve pain and reduce fevers. They include medicines such as aspirin, ibuprofen, naproxen, and others. After around 20 weeks of pregnancy, the unborn baby's kidneys produce most of the amniotic fluid, so kidney problems can lead to low levels of the fluid. Amniotic fluid provides a protective cushion and helps the unborn baby's lungs, digestive system, and muscles develop. Although this safety concern is well known among certain medical specialties, this is from the FDA, we wanted to communicate our recommendations more widely to educate other healthcare professionals and pregnant women. The issue affects all NSAIDs that are available by prescription and those that can be bought over the counter without a prescription. For prescription NSAIDs, we are requiring changes to the prescribing information to describe the risk of kidney problems in unborn babies. At around 30 weeks, NSAIDs can cause a problem that may result in heart issues in the unborn baby. If deemed necessary by healthcare professional, use of NSAIDs between 20 and 30 weeks of pregnancy should be limited to the lowest effective dose for the shortest duration. And NSAIDs include aspirin, ibuprofen, naproxen, and others. NSAIDs are used to treat medical conditions such as arthritis, menstrual cramps, headaches, colds, and the flu, so they're fairly common out there. Just be aware of that if you're pregnant and you are reaching 20 weeks. Be sure and consult with your obstetrician and don't take these products. Be especially careful of those products. All right, let's go to the grand jury. I'm going to cover this quickly. When we come back for the last segment of the show today, from quarter after 10 to 10:30, we're going to talk about class action lawsuits, and we're going to talk about mass torts. What's the difference in these two concepts, mass torts and class action suits? So there is also a Florida statewide grand jury that addresses problems across the state. They don't hear too much about them. They deal primarily with things that are going to be involved with more than one county, and sometimes they have that happens. The federal grand jury has between 16 and 23 members. They need the concurrence of 12 members required to return an indictment. They must issue before an individual can be tried for any felony offense arising under federal law. Federal grand juries lack the civil investigative power according to the Florida grand juries. Okay, so those two differences. The federal grand juries can return indictments for any felony, and they are subject to the same general restrictions of privacy and protect the identity of the people testifying before the federal grand jury. That's it for this segment of the Law Show. I'll be back with one of the lawyers from Kerrigan, Rankin, McLeod after this message. Yes, the time limits are called statutes of limitation, and they set a parameter in which a medical malpractice case can be filed. It can be up to 2 years. There are occasions where it can go up to 4 years. That's not very often. The key is, when did you know that malpractice occurred, or when could you reasonably have known? And that establishes the statute, but it's so case specific, it's so specific to each individual and each individual claim that the lawyer has to analyze that and then advise the client. But it is a factor that is very critical in a medical malpractice case. Bob Kerrigan for Kerrigan, Rankin, McLeod, and Thompson. What is medical malpractice? In many ways, it's similar to an auto accident. If a driver of a car is careless and causes an accident and injures someone, the driver is responsible for those injuries. If a doctor or employees of a hospital violate the rules of medicine, they're responsible for the injuries they cause. These rules of medicine make up the standard of care that doctors and hospitals are required to follow. Medical malpractice cases are expensive to bring and can be very difficult. We're required to retain qualified medical experts to assist the jury in understanding why what was done violated this standard of care. At Kerrigan, Estes, Rankin, McLeod, and Thompson, we accept meritorious medical malpractice cases where substantial injuries or a death have been caused by a doctor or a hospital failing to abide by the rules of medicine. Please see our reviews on our website at kerrigan.com.
Welcome back. I'm Mike McLeod, and I'll be your host for this segment of the Law Show. The Law Show is brought to you by the law firm Kerrigan, Estes, Rankin, McLeod, and Thompson. Our firm is a regional Northwest Florida law firm that represents people who've been seriously injured in accidents, and we represent families who have lost loved ones in serious accidents. We've been around for a long time, and we've hosted the Law Show for a long time, and so we hope that the show will provide helpful information to viewers and to clients. And this format of the Law Show allows you, the viewer, to text us during the show. We'll try and get you some answers. If we think your text or question will be helpful to other viewers, we'll repeat the question on the show and try and get you an answer. So we can be text at our regular phone number, which is 850-444-4444. It's all fours, in area code 850. That's our office. That's our mainline office number. But if you text me this morning, I'll get your text and we'll try and get you a reply. Also, my email address is mike.mcleod, M-C-L-E-O-D. It's on the screen there, at kerrigan.com. You can email me a question or a comment about the show if you like. Our firm represents people who've been seriously injured in accidents. There is no fee unless there's a recovery has been made. Our lawyers who handle these cases are board certified civil trial lawyers. Fewer than 7% of the lawyers in Florida are board certified. So on a previous segment of the Law Show, we talked about the 4 elements of having a successful automobile accident case. And I want to talk about the 4th element of having a successful case a little more on this segment of the Law Show. And that is, you can have a case where an accident where the other driver was at fault and you have a real injury that was caused by the accident. But in every one of those cases, we have to find for our clients a source of insurance or money to pay what the claim is worth. And that can be a difficult thing in some cases. And so I've got some statistics this morning that I want to share with you, and why this is a particular problem in Northwest Florida and in all of Florida. So according to the Insurance Research Council, 12% of all vehicles in the United States have no bodily injury liability insurance. And that is the type of coverage that is required on a policy to compensate an injured person who's been injured by another insured driver. So in the United States, 12% of drivers and vehicles have no insurance to pay your injury case. However, in Florida, and Northwest Florida, of course, 25% of the people that are driving in our Northwest Florida area do not have bodily injury liability coverage. And so if you're headed to the beach, you're headed to a movie, you're driving with your family, and through no fault of your own, another driver negligently hits your car, injures you or a member of your family or an occupant in your car, there's a 1 in 4 chance in Florida that that driver is not going to have any insurance that will compensate you. And the reason for that is that the legislature in Florida does not require Florida drivers to carry bodily injury liability coverage. So you'll say this morning, well, I thought Florida required drivers to have insurance. Well, Florida does require that, but only PIP coverage, and that's coverage that provides for a modest amount of medical expenses to be paid as a result of an accident. Generally, the cap is $10,000, and property damage liability coverage. Florida requires that you carry at least a little bit of insurance to repair the other person's vehicle. But Florida does not require our drivers, our citizens, people that drive automobiles, to have any bodily injury liability coverage. And I want to show you, illustrate for you how unusual that is. For example, in Alabama, Alabama requires their drivers to carry a minimum of $25,000 of bodily injury liability coverage. Georgia requires a minimum of $25,000 of liability insurance. Mississippi requires $25,000 of liability insurance. Arkansas requires $50,000 minimum of bodily injury liability coverage. But in Florida, the legislature doesn't require us to carry any. And so that is the reason why in Florida, fully 25% of drivers who cause accidents don't have insurance. So as lawyers who are trying to help people who are injured in accidents, we have to prove the other person was at fault. We have to illustrate the severity of the injury. We have to connect the injury to the accident. But then we also have to find a source of money to help our client. Otherwise, we're not doing them any good. And I mention this because it's so common for us to have good people come to us who have really genuine injuries that prevent them from working, that cause medical expenses, but the other driver who was careless, who might have been intoxicated, who might have been texting, completely at fault in the accident, doesn't have any insurance. What do our clients do? Well, there are other areas where we look for coverage. The owner of the vehicle, if it's different from the driver, if a person is working at the time of the accident, an employer can be responsible. And there are other kind of subtle areas where we can find other types of coverage. But in Florida, we can buy a type of insurance coverage on our own policy called uninsured motorist coverage. And look, we're lawyers who do trial work and who represent people who are injured in accidents. We're not insurance salesmen, and we don't sell insurance. But because this is such an important thing, I wanted to spend this time on the law show, which again is brought to you by the law firm Kerrigan, Estes, Rankin, McLeod, and Thompson. Our phone number is all fours, 850-444-4444. And you can, again, text me at that number, or you can send me an email at mike.mcleod@kerrigan.com if you have a question or comment. You may have a question about your own insurance policy. So in Florida, we can buy, it's an optional type coverage called uninsured motorist coverage. And it's reasonably priced as far as insurance goes. And uninsured motorist coverage is a type of coverage that you buy on your policy that stands in the shoes of the other uninsured driver. So if you have $100,000 of liability insurance on your policy, you can buy up to $100,000 of uninsured motorist coverage on your policy. And that means if you get hit by an uninsured driver, then you can make a claim against your own coverage. It's something you pay for. Some people are reluctant to make a claim against their own insurance, but this is something you bought and paid for and are entitled to. So if you're injured by an uninsured driver, somebody, one of these 25% that are driving around our area, then you have protected yourself and your family and other occupants in your car because you've bought this valuable coverage. So in fact, the legislature does require, if you don't want uninsured motorist coverage, the legislature requires your insurance company to have you sign a statement. I do not want this valuable coverage. But it comes up sometimes, and we have people that are wonderful people who are injured in accidents, not their fault, and they don't have uninsured motorist coverage. And it comes up too often. It's an easy coverage to buy, and it covers you and your family in the event that something like this happens. Uninsured motorist coverage follows you. So if you are driving with a neighbor, or if you're driving with a relative, or if you're a pedestrian, if you're on a bicycle, your uninsured motorist coverage will follow you. So if you're a pedestrian, you're hit by a car that doesn't have good insurance, your uninsured motorist coverage will cover you there. All right, another unusual thing about uninsured motorist coverage is that not only can you purchase that to protect you on your vehicle, you can stack your coverages if you elect to do that. And so if you own 3 automobiles, you can buy uninsured motorist coverage on each of the 3 vehicles. And let's just use that $100,000 example. You'll have $100,000 in the event that you are in any of those vehicles. However, in uninsured motorist coverage, you can elect, you have to pay a little bit of an extra premium for it, but it's reasonably modest. You can elect to stack those vehicles' coverages together. So if you buy stacked uninsured motorist coverage and you have 3 vehicles and you're insured with whoever, Allstate, State Farm, Progressive, any of these insurance companies, then you can add those coverages together. It's the only type coverage in automobile insurance or any coverage where you can add your coverages together to get a bigger number. So in that example, you would have $300,000 of available uninsured motorist coverage for you, your family who lives with you, and in some cases, an occupant of your vehicle. There's some subtle elements of that if you have a passenger or a guest in your vehicle. So we want to spend this much time on this because it's important. We can do a great job on your case. We can find witnesses who can help us prove that the other person was at fault in causing your accident. We can meet with your physicians and get a great perspective about how this accident is going to affect your ability to work, to enjoy life, to do the things you used to do. We can get your physician to project out future medical expenses, but we're not doing any good for you unless we can find a source of money to pay. And the easiest way for you to protect yourself is to consider buying uninsured motorist coverage. So I want to encourage people to get your policies out, see if you have uninsured motorist coverage. It's something that people, especially in Florida, because there are so many uninsured drivers, need to consider. One final thing about uninsured motorist coverage, it can also be underinsured motorist coverage. So let's say you're injured in a car wreck and the person who causes the accident does have insurance, but doesn't have very good insurance. And that is very common for a person who causes an accident to have, say, a $10,000 insurance policy. In a lot of injury cases, that doesn't go very far. But uninsured motorist coverage is also underinsured motorist coverage. So you can, and you have to take some steps to do this, and we do it all the time, you can resolve your case with the underinsured driver for their coverage, and you can leave open and still have a claim with your own insurance under your uninsured motorist coverage, which then becomes underinsured motorist coverage. Very important concept. So listen, this has been this section of the Law Show. I'm Mike McLeod for all the lawyers and partners with the show who host the Law Show each week. Our phone number is 850-444-4444. We can be texted at that number, and that's our main number. Stay tuned. For over 30 years, we've been part of this great community. Kerrigan, Estes, Rankin, McLeod, and Thompson, representing accident victims across Northwest Florida. if you've been injured in a car accident, it's hard to recover from a driver who has no insurance or who has insurance with low limits. It's typical for a person with no insurance or low limits not to have assets that can compensate you for your injury. So in those cases, we look to your policy to see if you have uninsured motorist coverage. Uninsured motorist coverage is coverage that you buy under your own policy that will protect you just in this event. And we recommend that all of our clients look at their policies to see if they have uninsured motorist coverage. It's really not very expensive, and it's good coverage that protects you, not the other driver. For over 30 years, we've been part of this great community. Kerrigan, Estes, Rankin, McLeod, and Thompson, representing accident victims across Northwest Florida.
Bob Kerrigan back with you on the Law Show. Thank you very much for watching, and thank you all very much for sending us text messages, which you do from time to time. You can text us right now during the show. We'll answer that. It's 850-444-4444. Not exactly a hard number to remember, but calling us, just dial the 4s. You dial 4 till somebody answers. Okay, that'll be us. But the text message, you have to have 850 preceding it, 444-4444. You can email me if you want to directly, bob@kerrigan.com, or you can email any of the partners of the firm and by accessing our website, which is kerrigan.com on the screen behind me. And that's one of our offices there. That building is downtown Pensacola, Florida. Glad for you to be with us, and send along anything you think we should talk about, anything that you think is of interest. We do specialize in injury and death claims, but we're here with the Law Show answering questions about the law general. If we know, if we don't, we will send a message or the inquiry on, or recommend that you contact somebody else that knows about your area of need, whatever that might be. And the Florida Bar has something called the Florida Bar Referral Service, which is a toll-free number in Tallahassee that you can call to have cases to secure a lawyer for the kind of case that you have. Our cases, the cases our firm handles, are injury and death claims, and all of our partners are board certified, and we're all well experienced in these cases, have handled them for years and years, all over, every kind of case you can imagine, and from airplanes to trains to trucks to cars, medical malpractice, products liability, prescription drug issues. They're all under the umbrella of the kinds of cases that we undertake. We covered the grand jury issues, the big picture of grand juries. For those of you who haven't been with us on previous programs, we discuss the state grand jury system, the statewide grand jury system in Florida, and the federal grand jury system. So if you have any questions about that, you can text me or email. We've covered that in the past, but if you missed it and you have an interest in that, you can tell me. Well, now I want to talk about something that is very common, because you can't watch a television program and have a commercial at some point in time in the evening that isn't about lawyers advertising that they're taking cases on certain kinds of drugs. The disclaimer that's on the screen is a travesty. If you've seen it, it is probably 13, 14, maybe longer lines of small print text on the screen that you couldn't possibly read in a million years for watching the TV commercial. And I don't know what the purpose of it is. Well, you have to do it. Legally, you have to do that. Well, it doesn't mean anything because you can't read it. It's like having small print on a billboard. Nobody's going to read that. But you met the letter of the law. Well, the law shouldn't be the letter of the law. It ought to be the substantive meaning of the law. It should protect people by having false or misleading information displayed. So I find fault with these advertisers for these drugs. But what kind of cases are they? What are you talking about? Well, you have cases that involve many, many clients. They're called either class action cases or mass tort cases. Well, what's the difference? Let me give you an example. Say a grocery store that has 10 million customers and all of their chains and whatever, any kind of big store, and they overcharge every customer a penny. Well, you couldn't bring a lawsuit for a penny, right? I mean, who'd do that? You have to pay a lawyer to get a lawsuit for a penny? And they say, well, you only lost a penny, so what are you complaining about? So class action suits are designed to bring claims against some entity, a business or whatever, that's overcharged or mischarged or whatever, small amounts to millions of people, hundreds of thousands, if not millions of people. The criticism of class action suits always comes from the organized business and the insurance industry, because they're the ones that have to pay, okay? The insurance companies have to pay usually, or the corporation that is taking the money. So this corporation that charges millions and millions of customers a penny more, and so they add $8 or $10 million to their bottom line, whatever the number turned out to be. So they're in great shape, and if anybody sues them, they only have to pay a penny, okay? Well, class action suits are suits that require them to refund that penny or some other remedy, a coupon or something else, to the people that have been overcharged, the customers. And a penny's not the best example, but a small amount of money, okay, would not justify bringing the claim yourself. You just wouldn't do it. So that's class actions. The criticism is, oh, well, the lawyers are making all the money. Well, that's true. The lawyers will make money by doing it. They get a percentage of what they recover. And yes, they're going to make a lot more than any particular claimant who gets an airline ticket or gets a coupon or something else, in terms of the penalty. But the idea is we can't allow businesses to overcharge or take tiny amounts from millions and millions of people. We have to have a way to stop that. And a class action suit is designed to stop that, to make the people who've received this money that they should not have received have to give it back or something equivalent back so that they don't profit by their own wrongdoing. It's a very simple concept, okay? It's widely misunderstood, and it's openly criticized by the people who have to pay it back. And they always say the same thing: greedy lawyers, greedy lawyers. I suppose everybody's got a level of greed to them, but greed has nothing to do with it. The lawyers are compensated for making the wrongdoer not profit by it. It's good stuff, and it's just the fabric of fairness. Class action suits are prominent in it, in the fabric of fairness, okay? Now, what about mass torts? What's the difference? Involves a lot of people. Everybody, for example, that took a particular weight loss medication and suffered kidney damage, let's just say, as an illustration of that. And you have like 5 million people maybe that took this medication and suffered kidney loss. The difference between a mass torts and a class action is this: where you have mass torts, you have the same wrongdoer, but you have greatly different damages depending on the individual. A person may have mild kidney problems. A person may have mediocre kidney problems. A person may have lost a kidney, or a person may have suffered some kind of cancer development because of this drug. So you have individualized damages, but you have a common wrong. Just like the company that overcharged everybody a penny, it's a common wrong. But the difference is, with mass torts, people have individual claims. Big difference, and they are not the same. They're usually in categories of claims. The criticism of mass torts is it's a business representing, thousands and thousands of people. You don't have the personal relationship between the lawyer and the client. They process claims involving, thousands and thousands and thousands of claims, and lawyers make a lot of money. And the result is good. It's better than you bringing the claim yourself for this reason. Let's say you have a case involving a drug that has caused kidney damage, for example, and you attempt to undertake that case, and you're going to sue a big manufacturing company or a major corporation. And let's say your claim's worth $300,000 or $500,000, whatever, less than $1 million. It's very hard for a lawyer to undertake that case, undertake that risk, advance all the money necessary to go up against a major corporation for an individual to be able to recover. So that mechanism of mass torts allows that kind of person to make a recovery at a standard contingency fee, which might be anywhere from 15, 20, 25, 30%, whatever it is that the individual person will have to pay. They're still better off than to try to do the case themselves. In most cases. Let's say, however, your case involves the loss of both kidneys and a shortened life expectancy, and your claim is worth $5 million. Well, in that case, it may be wise to undertake the case individually with a lawyer as opposed to participation in a mass torts settlement. They generally have categories of recovery for mass torts. It'd be like mild damage, medium damage, great damage, something like that. But they may not have a category for the claim for the loss that you have incurred, which might be catastrophic. And so that catastrophic claim should be evaluated by a lawyer to see whether it is wise for you to participate in a mass tort settlement process. Okay? And that can be evaluated by a lawyer. Many times, mass torts have been the only way you can make a recovery. And one of the champions of it in our area, which is remarkable, really, is Mike Papantonio. He was just remarkable in his early understanding. He's with the Levin firm. His early understanding of it. And Ailstock now is another local firm. They do a really good job with mass torts. But Mike Papantonio, he had the vision before anybody else did about how mass torts would work. And he's been very, very successful. He's recognized nationally for his work in that field. That's Mike Papantonio of the Levin firm. You're watching the Kerrigan, Estes, Rankin, McLeod, and Thompson's Law Show, where we talk about the law. Our firm specializes in injury and death claims. All of our partners are board certified and well experienced, and we have the highest ethical and legal rating by Martindale-Hubbell that you can obtain, and we're proud of that. Proud of the work that we do and the clients, the thousands and thousands of clients that we have. Please see our Google reviews on our website at Kerrigan.com. So until next week, Bob Kerrigan saying thank you very much for watching the Law Show. Be safe, and we'll see you next week.